Switch your camera. You should say something. Okay, that's fine.
ഒരു 4 മണിക്കൊരു ഓൺലൈൻ സെഷൻ ഉള്ളതുകൊണ്ടാണ് ഒരു ചെറിയ ഞെരുക്കം വന്നത്. Thank you so much for the wonderful session. Now we'll be having the online session by Advocate Anil Malhotra.
Good evening, everybody. Am I audible? Hello? Good evening. Can you hear me, please? Hello?
Audible. Yes, sir, you're audible.
Okay.
Sir, could we take this opportunity to introduce you, sir?
Yes, please.
For a
Please do.
moment.
Please.
We have a very distinguished speaker this evening. Advocate Anil Malhotra is a distinguished family court law expert with extensive experience in handling complex guardianship cases, particularly those involving international jurisdictions and cross-border child custody disputes. His expertise spans legal issues surrounding inter-country parental abductions, child welfare, and adoption laws. Frequently appointed as an amicus curiae by courts in sensitive guardianship matters, Advocate Malhotra is widely respected for his nuanced understanding of both Indian and international family law frameworks. His contributions have significantly shaped judicial approaches to transnational family disputes, emphasizing the best interest of children. Good evening, sir, and the audience as well as the session is all yours. Welcome to this session.
Thank you very much for the warm introduction. First of all, I'm very grateful and honored and indebted to the organizers, and particularly Honorable Justice Mushtaq, with whom I have worked as an amicus and with whom I've shared public platforms on issues regarding children, to have invited me for this session. Despite being in London for a break, I was not deterred by doing this session because it is a subject which is very, very important. And I must admire and admit that this endeavor of having a child legal assistance program and child support lawyers is a breakthrough in the child rights jurisprudence, because my experience of traveling in high courts all over India and the Supreme Court has shown me that there is no such initiative, there is no such progress, there is no such step forward in this direction. So this breakthrough of devising a scheme dehors the statutory rigors of an antique and outmoded Guardian and Wards Act of 1890 is, I think, a very healthy, constructive, and a very balanced, nuanced approach, which will go a long way in setting the path right. And it is my serious endeavor that the National Judicial Academy in Bhopal should take this on and use it as a pilot scheme in all high courts all over India. We need it very badly. Now, I would call my deliverance of my address today as the voice of the child. Now, let me give you a little background. India signed the United Nations Convention on the Rights of the Child in 1992. A child has a right to a nationality. A child has a right to a home. A child has a right to family life. A child has a right to live with both parents. We have signed the convention. We have enacted the United Nations Convention, and after the United Nations Convention on the Rights of the Child, we have created a Commission for Protection of Child Rights Act. We have created POCSO. We have created Right to Compulsory Education Act. And most of all, we have amended the Juvenile Justice Care and Protection of Children Act in 2015. We have brought the best interest of the child on the statute book. But how is it implemented? Where does it go through? I think this is where CLAP and CSL will come in. Nobody has joined the remedy with the implementation. Very few of us know that after we signed the United Nations Convention on the Rights of the Child, we broke down all the provisions, and in section 2(9) of the Juvenile Justice Care and Protection of Children Act, we defined the best interest of the child, which means the basis of any decision taken regarding the child to ensure fulfillment of his basic rights, needs, identity, social well-being, and physical, emotional, and intellectual development. Now, till about 2020, 2021, this definition was unnoticed. Everybody said the JJ Act is meant for orphan, abandoned, and surrendered children. I took up this definition in a habeas corpus in Delhi High Court, and I told the Honorable Bench that this applies to children whose rights have been violated and children who are in difficulty. The court heard me patiently. It incorporated it in a habeas corpus judgment. Justice Khanwelkar approved of it, and now everybody uses the definition in respect of a right, in respect of a child whose rights have been violated. One very basic feature of the convention, which we have incorporated in the JJ Act, is right to life. A child has a right to family life. Where is right to life? Article 21. But who talks about the right to life of the child? We have the Hindu Minority and Guardianship Act. We have the Family Courts Act. We have the Commission for Protection of Child Rights Act. And we have the outmoded and Anti-Guardian and Wards Act of 1890. We use these phrases and these words that the decision is for the best interest of the child. But do we really go into it? My experience of handling child rights cases, child dispute custody cases, where there is a foreign court order and there is one parent holding on to the custody, the parent who removes the child goes to the family court or the guardian judge and seeks singular custody and exclusive guardianship. In international terms, they think of it as obsolete. How on earth is a natural parent asking for exclusive custody and guardianship of his own natural born child? So our statute, instead of the best interest of the child, looks at the best interest of the parent who has removed the child. So what happens? Any custody petition, any habeas corpus petition, I do a lot of amicus, they're all divorce petitions. Nobody looks at the child. And unfortunately, the pleadings steer the court before the Honorable Bench in such a direction that the child is only a trophy to be won by the parent who has better rights. Now, it is in this context a child support lawyer under CLAP will come as a breakthrough and a miracle. When the matter reaches for the child to be interviewed by a psychologist or maybe a psychiatrist, maybe a counselor, it's too late. The child is already alienated. He's polarized. He's poisoned. His mind has been totally cleaned out. All of you who deal with the subject should read Justice Sikri's judgment in Vivek Singh versus Ramani Singh. He says openly that the child has been so long with one parent that it is not fair to decide anything. Until a level playing field is reached, no determination. So I think the designing of this scheme by Justice Mustak is a breakthrough in the sense that the child will have an independent lawyer to speak for the child. The envisioned thought process of a child support lawyer will be that the counsel amongst you will not be holding a brief for the mother or the father. You will be holding a brief for the child. You will tell the honorable judge or the court, I am going to put in my counter or I am going to put in my petition, pleading as a child support lawyer independently. Now, what comes before the court is all disguised, cluttered, poisoned, fractured, manipulated versions which are nowhere near reality. If as a counsel you will step into the litigation at the very entry of the litigation, you will be able to decipher as counsels what is the reality. No child hates his mother or father. It is what the parent feeds, it is what the extended family puts in, that the child starts believing. And the child is so vulnerable. I have seen for myself that the child speaks the language taught for the simple reason that the child does not want to lose the sympathy of the parent in whose control or custody the child is presently with. So vulnerable as the child is, the child speaks the language of what he is taught. And I think until the court steps in, some courts don't. Some courts interview the child. I've seen in Bombay, the child is taken in chamber by lady judges and they speak to the child. In Supreme Court, they talk to children. But it's too late when the matter reaches up to the Supreme Court. I've seen cases where children are separated. One is with the mother, one is with the father, one is abroad, one is in India. By the time Supreme Court decides the matter, neither of the children want to go back and the family split. I've seen parents crying in court saying, what do we do? Delays the process. So that is something in the context of the voice of the child to be considered at the earliest possible court hearing is, in my humble view, an absolute necessity in India. Because of cross-border migration, you have it in Kerala. I practice in Chandigarh and in Delhi. It's equally high in both jurisdictions. We are 1.3 billion, over 30 million live abroad in about 180 countries. Our potential of migration is immense. And fallout of marriages, dissolution or irretrievable breakdown often triggers off child being with one parent, and then the child has no means to communicate. So it is in this context that a child, before he is polarized, brainwashed, or he is given an opportunity to feed tutored views, his version must be considered. There is an absolute necessity for an independent counsel in court to air his views and his best interest. The child is not a trophy or a prize to be given to the parent who is able to prove his preferential custodial rights. So, for a parent to say, I want the child because I'm doing better, is not a good idea. I have seen habeas corpus petitions where volumes are filed, but there is not a single page on the child. A private detective is hired to spy on the spouse. There are all kinds of allegations, good, bad, ugly, but best interest of the child. A question which I ask myself, we have taken the definition of the best interest of the child. The Hindu Minority and Guardianship Act, the Family Courts Act, everybody says best interest and welfare of the child shall be paramount. But a question which I ask myself, where is the process of determination? Where is the process of analysis? Where is the process of adjudication? Where is the process of finding out as to what is the best interest of the child? Who will do it? How will it be done? By the time pleadings are filed, child is already with one parent for a long time. Referring the child to an analysis or an agency outside the system of the court, I think that delay, that unfamiliarity of the specialist with the process of determination defeats the entire exercise. So it is in this context that you who contribute as child support lawyers must think very consciously of what is the best interest of the child. And invariably, 9 times out of 10, you should think of joint parenting, shared custody, and equal access. Now, my experience has taught me leaving the child alone with one parent is fatal for the best interest of the child. And even if the other parent is given access, visitation, or online contact, it is very, very successfully defeated. So that leaves the child in a bigger confusion, in a bigger mess. Your job to facilitate as a child support lawyer on representing the views of the child will also include an additional responsibility of how you will use your appearance before the court to ensure that the access, visitation, custody to the other parent is secured, is actually verified, and is actually done. In my view, calling a parent to the court and saying you meet the child in the chambers or you meet the child in the court premises is an antithesis of child law. I have been given assistances, I have given assistance as amicus, where judges in our jurisdiction in Chandigarh have told me, take the child to a shopping mall, take the child to a hotel, take the child to a play place. Let both sides be present. Let the child feel comfortable. Calling a child to a counseling center in the court premises, which is surrounded by lawyers in robes, maybe police officers, is I think overawing and is a very big mental setback for the child. Now, these are things which, from my experience of 40 years, I can suggest to you, you have to keep in mind. You, as the lead court in the country, with the pilot scheme, have a very big responsibility in taking forward something which is going to be an example for the rest of the country. You, as child support lawyers under CLAP, will learn from experience because there is nobody to teach you. I don't think anybody can teach you this. You will discover from every case as you graduate and move on as to how will you secure the best interest of the child. So you are going to be agents in motion of a letter of law which is in a coma, as I would say it very bluntly. We have created these very nice words. A lot of benches, lot of courts have given their interpretation. Lot of courts have said what it includes. But I think what is the best interest of a child will vary in every case. And you as assessors, maybe as parents, maybe as brothers, maybe as sisters, will realize that this child's needs are different. I have assisted Justice Mushtaq in a matter where an autistic child was in Dubai and the Honorable Court gave access. The judgment has been upheld by the Supreme Court. It was a very novel method of taking the habeas corpus jurisdiction, but best interest of the child was secured. And the welfare of the child was secured. It needed a lot of effort. I think I acted as a child support lawyer. That's what I did. And that's how I think the scheme is brilliant. I got to know it yesterday. I'm not in the country, but still I got up very early in the morning. It's 9:30 in the morning here. But then I found it was so invigorating and it was so good that it's excellent. I am a part of the International Academy of Family Law Lawyers, which is a very close-knit community of family lawyers worldwide. We function through committees. I'm currently the secretary of the IAFL International Child Relocation Committee. So we are circulating a questionnaire. We're trying to find out how do we secure the best interest of children? And we are giving the questionnaire to everybody in the world. And I think we are all child support lawyers. We are working without briefs. We are trying to find out a formula internationally. We are not a signatory to the Abduction Convention of 1980, but we are a signatory to the United Nations Convention on the Rights of the Child. We are duty bound to secure the best interest of the child. So, what do I think we are doing? We are all agents of change. You probably have the flag bearers' position as pioneers, and you have to carry it forward. The success of the scheme is in your hands. I will be happy to come back again whenever needed. I think I have 20 minutes to do. I have done my 20 minutes. If anybody has questions, I'll be happy to answer.
Grateful to you, sir, for the enlightening session. In fact, we being the pioneers, we are not too very sure that we'll be able to give magic wand results. Still, we are looking forward to it. And we are very happy that we have been recognized so well by an eminent person like you. Thanks a lot. Thank you for having spared this time for us.
Grateful. Thank you very much.
We have Honorable Justice Dias here. His Lordship is the chairman of the steering committee of the CLAP. Sir, would you like to have a...
Good morning, Mr. Anil Malhotra.
Sir,
Yes.
grateful, sir.
Yes. As Advocate Parvati said, we are just in the inception. We are just started the scheme, launched it. This is the first panel which is there. All the lawyers have been selected, and we are in the teething process. And with inputs gathered from each lawyer and the experience that we gain, we think that we will modify the scheme as time goes by. And we have kept a continuing mandamus pending before us, myself and Justice Mushtaq are hearing the matter. So on the judicial side also, so we thought we will improve on it. So thank you for all your valuable inputs and the advice that you have given to all the child support lawyers. And we look forward to working with you in the future also. Thank you.
Grateful, sir. Grateful, sir.
Now, due to paucity of time, we'll have a very brief session by our respected Baiju sir, Family Court Judge Ernakulam. Actually, sir cannot deal with the entire session, but sir will just give a nutshell of what sir wanted to convey. Please.
Honorable Justice. What do you want? Honorable Justice C.S. Dias and Dr. Mohit, Member Secretary Kalsa, Mrs. Jubia, Director, Mediation Center, and dear Clap Lawyers and Secretary of DLSS. Good evening to all. So this is the last session of today's training program. You already had other informative and brainstorming sessions, and now we are at the concluding session. Our topic is family law governing children. The topic essentially refers to the provisions of various statutes that comes within the jurisdiction of family court. I'm afraid that I cannot have a detailed discussion on this subject due to paucity of time. Anyway, I will begin with the terms guardianship and custody. In family courts, we often come across the terms guardianship and custody. Very often, we are using these two terms as synonyms or rather complementary. But there is a sharp, as you all know, there is a sharp distinction between a guardian